SJC 12047, Commonwealth v. Ashani Duke.
Attorney Lehman.
Good morning, Your Honors. Attorney Lehman for Mr. Ashani Duke. This case really demonstrates the problems with felony murder. And I know Mr. Duke is not entitled to the protections that came with Commonwealth versus Brown because he was tried in 2015. However, that case is instructive as a sort of framework or backdrop to what exactly happened in this case. It also demonstrates the serious problems with the Commonwealth relying upon one singular witness for its entire case, especially when that witness is an accomplice and co-defendant. What I would like to address this morning is the accomplice issue under 33E, as well as my motion for a new trial, which was denied because that has related corroboration and accomplice issues in it. And then I would like to address an issue which was not raised directly in my brief, but which, as I was going through the cases, the jury instructions and the facts, I realized it should have been raised in my brief. And I sent a letter last week notifying my brother and the court that I want to specifically talk about a footnote in Commonwealth versus Tejada, footnote 12, where this court noted that the 2013 jury instructions were not sufficient to protect the defendant or to instruct the jury on what they needed to find with such circumstances. So I think it was Justice Lowy who said during the Arthur Davis arguments last year that if juries love anything, it's corroboration because it gives them comfort, and there was none of that in this case, or there was very little. As I raised in my brief, the police didn't really try to corroborate anything that Julian Hawley told them. They didn't search the house where he said he was living at 26 Dearborn. They searched another house where he wasn't currently staying. They didn't try to find the gun that he said he had just prior to this robbery. He conveniently left his .357 someplace else, presumably at 26 Dearborn. But they never tried to find any of that information. So I listed a number of things that they didn't do. And so when you have a case like this where the entire thing rests upon Julian Hawley's shoulders, and Mr. Duke is put in the circumstance of trying to cross-examine a man who there's not really any way to truly cross-examine him because police have not done this proper investigation. It puts him in a very bad circumstance.
Counsel, let me interrupt you there because looking at the record, I don't know how you can say that there's no corroboration here because the fellow that was shot testified to going to the sister's house and getting this call and then meeting up with these two folks, which is the backside of what Hawley testified to, that they were all together and that your client made a call. They went to the restaurant, the Popeyes, and then went to the place where they met up with this with the fellow who got shot in the leg. So there was corroboration of what Mr. Hawley said by virtue of the fellow that was shot and testified.
Well, you have to look at the timeline of when he gave that information because he gave 3 different statements to police.
Sure, that's true, and he was subject to cross-examination about that. So you still have him testifying, irrespective of the fact that I think it came a year or two later when he gave all of that detail. It's still the tails to the same coin of the fellow that got shot in the leg, saying that this is how it went when I stopped by my sister's house to check on it on my way to watching this football game. So how is that not corroboration?
Because he had access to all of the discovery, which would have included all of Dancy, the robbery victims, all of his statements to police about what happened. And so it would be incredibly easy for Holly to, at the point that he got his cooperation agreement,
What
to then
about the, what
say,
about the cell phone records?
he is the only one. It's Holly who says this number belongs to Duke. All police needed to do at that point was pick up the phone and call and see who answered, but they didn't even do that. Instead, they just relied upon Holly and then made assumptions from there that it had to be his number. And I just, in a case like this, it isn't enough.
Mr. Lehman, I get your concern about accomplices, and it's warranted. But what's your cooperation rule? Because when we have immunized witnesses, we just, we don't require much. And I know you want us to go further than that, but what's your rule?
Well, there are a number of other states that do have corroboration rules where you have to have some evidence, that some other independent evidence other beyond Holly's word for it, or the fact that Holly could have gotten information from all the discovery that he got to back up what he's saying, in which case this would have been the police searching his house and finding the gun that he said. Why wouldn't you want to know from your key witness that the gun you had in your possession, which could have fired the bullets, because it was a .357.
So Justice Georges gave you evidence of cooperation, but what you want is our rule to be, there has to be evidence that is unknown to anybody else but an insider.
I think it's a little too convenient to say that corroboration, that he had corroboration because he matched up his story to what Dancy said when he had Dancy's statements in his possession.
I'm asking you the question. Does the corroboration have to be unknown to anybody but an insider? Is that your rule?
I wouldn't say that it's unknowing to anyone but an insider, but that it's some outside investigation by police to back up what he's saying, rather than just having an accomplice who had every motive to lie. I mean, he said it in phone calls that he would say anything to get out. He's facing murder, and in the end, the murder charge goes away because of the testimony that he gives. And what greater motivation is there for someone to say whatever's convenient? And he has the evidence right there with the discovery of everything that Dancy said happened.
But the cross-examination and impeachment isn't enough here?
I do not think it is, because that's all they have is Holly, and you can't truly impeach a witness like that when there's no other, when the police don't have an incentive to go out and do further investigation. I mean, they admitted what they didn't do, and the fact that Colin's EBT card was found underneath the couch in the Dancy apartment, and they did nothing with that and didn't even reveal it until 2 months before trial. You have the witness, Cynthia Perrin, who says 2 weeks prior to this, there were young Black men breaking into that apartment and things went missing. And that's why Dancy was there checking on his sister's apartment that had just been broken into. And she said the young men that she saw fighting Dancy when she looked out her window looked like the same young men who had been there 2 weeks prior.
Sure, but she testified for the defense, though. So again, the jury has all of this, right? They have all of this. They make their credibility determination, and they chose to convict. All of this was there. All of the stuff that he did, all of the crimes that he did, all of the things that he said about what he would have said because the Collins was his best friend. They had all of this. In the trial counsel could exploited all of this. So again, I go back to Justice Gaziano's rule question to you. What would you have us do?
Put a higher burden on the Commonwealth and law enforcement to do something more when you have this kind of case. I don't know how often you have a kind of case where literally the entire case rests upon the shoulders of one person who has every incentive to lie. That when you get this circumstance, and my client has gone away for life, that the duty is higher, that there is a bigger standard there, or should be, because juries can't be relied upon to discern this. And that is what the law review I cited in my brief, and there's a bunch of other studies and law reviews that come up in that one, and why other states have incorporated this rule, is because juries can't be relied upon to discern the truth with such a witness. And
Weren't there,
the same with
weren't there some
eyewitness testimony.
statements of the defendant that were consciousness of guilt statements that were presented by the Commonwealth?
I believe it was that he was in the convenience store at the time.
Right. They checked that videotape, I think.
Yeah, I think there, I know there was some extra time, and there was an issue of how late the store owner stayed open and whether or not they
But
were able to
nonetheless,
get the
would that
tape.
count as corroborative evidence with the, because you've got a rule that sort of combines, if there's a Bowden situation with questioning the investigation, and if you've got a cooperating witness, an immunized witness, for instance, that you need some additional corroboration. I'm wondering if that type of consciousness of guilt evidence would constitute the corroboration or not.
I don't think the store video by itself, just the fact that he said this is where I was and then the video didn't corroborate that, can be enough in a case like this.
How about giving the cell phone number that was deactivated?
I just, if that's, I mean, if, I don't know what was the mindset at the time. You give a cell phone, I mean, that was the number that he had, and you know, was using his mother's phone. I don't think with this kind of case that those two things by themselves are enough to put a person in prison for life when you have this kind of witness testifying against him. And I'm speaking specifically about this particular case with this kind of witness, where the Commonwealth admitted that the entire case rested upon his shoulders, and you don't do anything more. And it's, I think under, when the court looks at this whole case and everything that happened, it's just, there's some, it's not all that, this was not a fair case for Mr. Duke, and you have him charged with felony murder. I mean, the other thing I wanted to raise with regard to the corroboration is what I raised in my motion for a new trial with the cigarette butt. So the Commonwealth, in its closing, stated the circumstance of the retrieval of the cigarette butt, and then the prosecutor stated that's corroboration, folks. That's what he said in his closing, and in fact, that wasn't true, because that cigarette, which was used as corroboration, did not belong, it was not Julian Hawley's, it was somebody else's. And because the Commonwealth didn't test it, chose not to, which they could have, and I argue they should have, the jury heard that as a piece of corroboration.
Right.
I'm sorry, Your Honor?
Couldn't the defense have tested it?
I think that is for evidence that's in the custody and control of the Commonwealth taken in a case pretrial, to put that burden on defense counsel would not be fair, because you're saying that the attorney needs to move for funds in order to do the testing, that and the results, regardless of what they were, would then go to the Commonwealth as well, because it's evidence in their custody and control. And that's to say an attorney needs to do that and run the risks of whatever that evidence is going to show when you have no idea is not fair. That should not be put on the defendant. The Commonwealth should have done it. And because they didn't do it, it deprived Mr. Duke of a potential eyewitness, because the fact that that cigarette was freshly smoked right there in that location meant that that individual was at that location at the time of the shooting. And so he was either a third-party culprit or he was a witness, because he was there at that time. And now he was unavailable because he had counsel and I couldn't talk to him. So if that had been done previously, it would have been a whole different circumstance. So you have that piece that was specifically used as corroboration, which goes away. You have the cell phone number that Holly provided, but then was never corroborated by police by actually calling the number. So there's no actual affirmative evidence tying it. I mean, yes, that number is shown to have called Dancy. Dancy says, I received one phone call from someone I thought was a friend, and that was it. So he doesn't corroborate what Holly said. And it just, it's not enough in this case to not require more when you have this kind of witness. Now, the one final thing I wanted to address, if there's no other questions, was this issue under Tejada with regard to the jury instruction. So this court said in footnote 12 that the current model jury instructions regarding felony murder do not provide adequate guidance to a jury in the circumstances presented in this case. So you have Dancy's testimony that
How is Tejada, Campbell, and Bolero implicated when the Commonwealth's evidence is that your client was the shooter?
well, first, I think it's an open question whether this court has not said that if the co-felon is killed, whether or not that falls, whether or not that should be included under.
But look what happened in Tejada and Campbell and Bolero. They're, innocent people are killed, by the cops, essentially, right?
I believe I thought in Tejada it was one of the other co-defendants who was killed.
But anyway.
But Tejada himself was
Campbell's
the
a
driver.
rider killed by the police. Bolero's a police officer. Tejada's an accomplice. But in this case, in the Commonwealth's evidence, is your guy just starts blasting and shoots one guy in the leg and kills his accomplice. Isn't that what felony murder is all about?
Well, I don't think it's as clear.
Let me finish my question.
Okay.
People, we want to say that people that do dangerous things like armed robberies, there's constructive malice, and I know it's changed since Brown, but here we have a robbery and he starts firing at people. How is that not consistent with the theory of felony murder?
Well, first of all, I don't think the facts in this case are as clear as that, because what Dancy says happened and what ballistics say, I mean, ballistics doesn't rule out there being the possibility of a third gun. It's unclear the types of projectiles, whether they could have been from the .380 that Collins had, whether Collins could have shot himself.
We know the .380 did not fire the fatal round, right?
Well, when I reread the ballistics testimony, that still wasn't clear to me, but I know the Commonwealth argued that. Lieutenant Murphy, I think, who was testified for as the ballistics expert, said that there could have been other, I think the casings, .380 casings could have been trampled in the mud or moved, and he didn't find any, but that didn't mean they were precluded, that the gun couldn't have fired more. There was one projectile, I think it wasn't clear whether it could have come from a .38 or from a 9mm.
I thought the testimony was that he was shot in the head. It wasn't the .380, could have been a 9mm.
But it also could have been a .357 Magnum, I mean, which is the gun that Holly owned. So I guess they didn't do a search in the area to see if there was another gun. Like, I believe they searched they didn't search behind the buildings where people were seen running. At least not that I could find.
I'd like to ask you one quick question though. All of this, ifs or coulds or shoulds, isn't that taking the facts in the light most favorable to the defendant?
Well, I'm asking this court to look at the whole case under 33E, and so I have to include the ifs or the should, because of the things that did and did not happen in this case.
No, but
I believe my client is unfairly serving a life sentence for.
You're asking us to say that this case is legally insufficient because of Bolero, Campbell, and Tejada, based upon the evidence that you put in the light most favorable to your clients, correct?
I'm saying that the jury could have, especially because of how the verdict slips came down, which was they disregarded they did not find him guilty of premeditated murder with transferred intent, meaning they didn't find that he shot Collins while meaning to shoot Dancy. They picked the felony murder, and because of that, and because the 2013 instructions were insufficient, if there was any type of evidence that could fit,
they're insufficient, assuming it's a Tejada issue.
which I'm saying that it, based on the evidence, it was, because it wasn't as clear as how the Commonwealth says it was in terms of the ballistics and Dancy's testimony himself. And also taking into account that Hawley's testimony was very self-interested in what he claims that he saw. So Dancy's story about the shooting and what happened is a bit different than, I think, what Hawley said he saw from a distance, which I arguably, if Ronnie Diaz, who was right there at 102 Robert Dyer Way, could not even see Collins' body until he turned on the porch light. I don't think that Hawley could actually see what he said he saw from the distance of 73 to 102. So yes, I think the evidence is such that the jury could have, since they found him guilty of felony murder, they could have done it on an improper theory, and it's unclear which theory they did. That is, that somehow Collins ended up shooting himself, or Dancy shot him by accident, or that Mr. Duke shot him. So in that circumstance, I think the court should reverse, because it's using the 2013 jury instructions on this, and they're first told they don't have to find that he shot him, but under felony murder, under Tejada, they do have to find that he deliberately shot them. And I think with these facts, they should have been instructed, you need to find that Mr. Duke actually shot Mr. Collins.
Thank you.
Thank you.
Attorney Shepherd-Brick.
Thank you, and may it please the court, David Shepherd-Brick on behalf of the Commonwealth. I would suggest first the jury didn't reject the theory of transferred intent. They were never asked about that theory. They rejected the idea that the murder was premeditated, which I think based on these facts is reasonable, because it seems like, there was testimony that the defendant was saying, let's get out of here, but he ultimately fired, I think the evidence suggests, 2 bullets, one which struck Dancy on the leg and the other which killed Mr. Collins. So I think this is a classic case of post-Brown felony murder. It's a second degree, so it's at least a third prong malice. He fired 2 bullets from point blank range during the commission, or in this case, attempted commission of a light felony of armed robbery.
Well, let me ask you about the accomplice situation. It's always struck me as odd. If you have an immunized witness, the witness has transactional immunity, you can't prosecute them. You have an accomplice agreement. I know they can be prosecuted for perjury, but how rare is that, right? So we give an instruction, or the statute requires for an immunized witness, there'd be some cooperation. Given what counsel has pointed out about the wrongful conviction issue and accomplices, why don't we have the same rule for accomplices?
Well, I mean, the corroboration requirement for immunized witnesses is statutory. I understand that there's
I just said that, right?
Right. I guess I can see, the suggestion that, well, these witnesses may be unreliable, so we want some limited corroboration. I don't necessarily think that you need to answer that question in this case, because I would suggest there was significant.
All right, I'm asking you the why. Why don't we have the same rule? Why don't we impose this rule, given the horrors of accomplice liability or accomplice testimony that has been pointed out in the law review articles and the literature in wrongful convictions? How does it make any sense not to have a cooperation requirement when we do it for immunized witnesses?
I mean, I think I would say the Ciampa instruction goes a long way to point out the problems to the jury, saying, give this person a really hard look, because they're getting something big out of this. He was promised consideration He ultimately did plead guilty to certain charges. Murder wasn't one of them.
So we have the
But-
same instruction for immunized witnesses, right?
Yeah,
You scrutinize it.
right.
Why shouldn't we judicially impose a cooperation rule? What makes sense about distinguishing between the two?
Well, I don't know that necessarily without the legislature's requirement of corroboration in a statute, I don't know that it would be necessary. I think it becomes necessary because the legislature has made, and this court has said when discussing this in the past, that look, the legislature has made this a requirement. We don't, from a common law perspective, we don't think we don't need it. But because they have made a special exception for these witnesses, there is this extra requirement. And if the legislature wants to add that requirement, they can. I don't know that it's necessary.
Right.
In terms, I want to go back to Justice George's question about the corroboration, and particularly, so in the second statement Mr. Hawley made to police, he actually mentioned the trip to Popeyes and they went there, they made the call, and then went to, he got out, made a call, and then they went to Robinson Gardens. So there was a lot of corroboration that Hawley gave to the police before he read the police reports, including that particular stop, which lined up with what Mr. Dancy ultimately said and ultimately testified to. Also, the cell phone, the most significant piece of cell phone corroboration came through the defendant's expert, who said that the name in the phone in the call log is the name that was associated with that number at the time of the call. And there were calls from the 5654 number to Mr. Hawley's cell phone that came through on November 25th, the week before this, as listed under the contact Ashani. I think it was spelled with an I instead of two E's, but that was a week before the murder. So, in terms of Hawley being the only one to link the defendant to that cell phone, that's incorrect. He would have, unless he had been planning to set him up for the robbery and murder a week before it had happened. So I think there is significant corroboration there. And then the ballistics. The victim was killed by a 9mm. The ballistician said the bullet is consistent with a 9mm. It is inconsistent with a .380. There were no other guns found. The suggestion that there could have been other guns, yet the ballistician said, I can't, because the bullet is so damaged, I can't rule out that there was a third gun. But other than that, there's no evidence of a third gun. And Mr. Diaz, who came out and found Mr. Collins' gun, which was right next to him, and then Officer Davis, who arrived on scene, recovered the gun, and then also found one of the shell casings and the projectile, didn't find any other guns on scene. So I think it's pretty clear that there were no other guns, and that only the 9mm fired any bullets, given that the .380 didn't reload and was found loaded. In terms of, I wanted to address the cigarette butt very quickly. It's not newly discovered evidence because the defendant could have asked for it to be tested. That sort of thing happens all the time. But I would suggest that it didn't really, it corroborated Hawley on a very sort of tangential piece of his testimony. And defense counsel even brought out at trial that it probably wasn't his, because where he said he was parked, he would have, if he was in the driver's seat, he didn't say which window he, sent it out. But if he had sent it out the driver's side window, which would have been the most likely direction, it would actually have gone in a complete other direction from where it was found. So, and
The cigarette, after the shooting and the police find the cigarette that's actually tested, do we know if that's the same one that was actually observed lit?
We don't. The testimony was that the witness came out to her, came out and saw, sort of the scene. She'd seen that she had a flat tire, but she, also saw people were laying on the ground. So she went and sort of tried to help out with that situation. And then she came back to her car. She found a cigarette that did not appear to be wet and did not appear to be like smushed or stepped on. So she thought, and it had just started raining, so there was some suggestion that it appeared fresh. I mean, based on what came out after, during the motion for new trial, I know the owner of that cigarette ultimately didn't cooperate with defense counsel. He did speak with our investigators, and that was provided to the motion judge, which he basically said, I was in there around that time, but I certainly wasn't there I wasn't there when there was any murder or any shooting, and that's my brand of cigarettes, and that's what I smoke. And I think the motion judge properly found that was, that evidence did not outweigh the prejudice to the Commonwealth, which in this case, granting a new trial, the prejudice for the Commonwealth would be significant, as Mr. Hawley is deceased.